For a third time.
That's seconded. The Honourable Ms Franks.
President, I rise to make a third reading contribution to this bill. During the debate on this bill, as members know, I raised the clause around the removal of children. I asked many times for clarification on the consultation on this, and I note that at 6:13 p.m. tonight I've received a piece of correspondence that's been addressed to the Attorney from the Law Society's Chief Executive, Stephen Hodder, on behalf of the Law Society. I won't read the entire document, but I'll note that it's dated today. I'll note that we received it at 6:13 p.m. because I'm sure that that was as fast as they could turn this around. I'll note that while it refers to their previous response with regards to the commercial leases, that this makes further comment with respect to the proposed amendments that relate to the removal of children. I'll note that it says, "The Society notes that the Amendment Bill contains the following amendment to the Act with respect to the removal of children. Without derogating from Section 25, an authorised officer may, for the purposes of ensuring compliance with any direction under that section, remove a child from any premises, place, vehicle or vessel to a place of residence of the child or to a hospital or quarantine facility as the authorised officer thinks fit, brackets, and may, in doing so, use force as reasonably necessary, in brackets." The Society goes on to note that the State Coordinator or an authorised officer may remove or cause to be removed to such a place as the State Coordinator or authorised officer sees fit any person or animal, or direct the evacuation or removal of any person or animal already. Furthermore, under the Act already, the State Coordinator or an authorised officer has the power to use such force as is reasonably necessary in the exercise or discharge of a power or function under Section 25 of the Emergency Management Act. The Society goes on and to state at point 8 of the letter, say, "The Society questions the need for the amendment, not just because such powers already exist under the Emergency Management Act, but why these specific, albeit temporary powers with respect to children are being sought by the State Coordinator. 9. In particular, the Society questions the need for such provisions, i.e. have the police been having to frequently physically remove groups of children and young people away from public areas? If so, is there data that can be provided to justify the need for specific powers to remove children? Or is this a measure that police anticipate they may need to exercise as restrictions start to lift in South Australia? 10. Overall, insufficient information has been provided with respect to the need for these provisions, and the Society has a number of questions around them. For example, as children and young people are a vulnerable group in our society, what safeguards are in place? Given that police may use reasonable force to remove, will subsequent reporting requirements also be in place, particularly where children are not returned home to their families but taken to hospitals or quarantine facilities? How will an authorised officer determine a child's place of residence? Also, how are these powers likely to impact Aboriginal children or children under the care of the guardian? Will children who are removed under these powers also be subject to fines/penalties for breach of relevant SAPOL directions relating to public gatherings? And concludes with, given the significant breadth of the current emergency powers in South Australia, the Society questions the need for these specific powers. While it is anticipated that the powers are sought to remove children congregating in large groups and not complying with social distancing requirements, which can already be done under the Emergency Management Act, it is concerning that specific provisions that relate to children, including the use of force to remove them, have been introduced with little information to justify why such measures are necessary and proportionate. Mr President, I seek leave to table this letter so that it's at least in the record of the debate on this bill. It is. I think, Mr President, that it is a travesty of process that we have not been given any reason for these extraordinary powers, that no due diligence has been given to their implications, and that groups such as the Law Society have not been heeded or respected in terms of any consultation on these powers. It is, I think, beholden on us as legislators to take up some of those suggestions that the Law Society has been making. We have approved some extraordinary powers. We do have a COVID oversight committee, but we do not have the reporting regime that New South Wales has on the use of their powers. So with those few words, Mr President, I think that without strategic and specific reporting powers, that I urge members of this council and in the other place not to continue to accept the argument the police want it as the argument that means that the police get it. I want a puppy for Christmas, Mr President. I'm not sure that I'll get it. Certainly without good reason, the parliament should be not giving the state coordinator Christmas presents of being able to use force against children.
The question is that this bill be now read a third time. Those for the question say aye. Against say no. The ayes have it. Clerk.